Employment Law This Week. I'm George Whipple. Our top story, the Sixth Circuit upholds a ruling against ex-employees for a trade secret violation. The Sixth Circuit has upheld a ruling that a group of workers at a fastener company used confidential drawings from the company to design, manufacture, and sell competing parts for their new business venture. On appeal, the former workers argued that they were filling a gap for customers, not competing with the original company. But the Sixth Circuit found that this argument ignored undisputed evidence in the case. Peter Steinmeyer has more on what employers can do to protect their trade secrets.
There are a variety of things that employers can do to protect their trade secrets. First, to the extent that an employee has access to sensitive information, the employer should have them sign a confidentiality agreement. Second, employers should ensure that access to confidential information is restricted to a need-to-know only basis. Three, employers should take an inventory of what they have that's actually secret. They should know what it is that they're concerned about, and they should take appropriate steps.
On a related note, last week the House passed a bill to federalize trade secrets law. The legislation now heads to President Obama, who has promised to sign it. U.S. financial regulators seek comments on a proposed rule restricting incentive compensation. Several financial regulatory agencies, including the FDIC and the SEC, are looking to ensure that incentive compensation balances risk and reward. The proposed rule would require that up to 60% of certain compensation be deferred for as long as 4 years, and firms have the power to claw back incentive pay for at least 7 years. The new rule reflects the 10,000 comments that came in for the original 2011 proposal. Musicians who perform in seasonal concerts for a Pennsylvania orchestra are employees, not independent contractors. That's according to the D.C. Circuit, who ruled that the orchestra members are indeed employees and have the right to engage in collective bargaining through a union. After noting that there are a variety of unharmonious tests for independent contractor status, the D.C. Circuit deferred to the NLRB's decision on the matter, citing court precedent that held NLRB rulings in cases with conflicting views should stand. And in California, we're seeing a new strategy from the NLRB on employee classification. The board's Los Angeles office is arguing that Intermodal Bridge Transport's alleged misclassification of its drivers as independent contractors is an unfair labor practice because it deprives them of rights granted to employees under the NLRA. With the continued growth of the gig economy, even companies that have taken proper care in the classification of their independent contractors may face NLRB action on this front. And that brings us to our tip of the week. Michael Brazel, Executive Vice President and General Counsel for Fresh Direct, is here with some advice on dual representation for litigation claims.
Employment litigation claims are often brought against both the company and its management. These types of cases often provide opportunities for the company and management to be represented by the same counsel. That is joint defense. Gives the company an opportunity to save litigation costs, reduce time and effort in defense of the litigation, and equally important, provides the company with an opportunity to stand behind its management in defense of unwarranted litigation. In assessing whether joint defense is appropriate, counsel must determine whether management and the company's interests will be adversely affected by dual representation. If not, the parties can consent to such representation. Such consent should be set forth in a detailed letter explaining the potential for conflicts in the future.
Thanks, Michael. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.